because you have to take notice when the Supreme Court decides that they want to hear this many cases involving ineffective assistance of counsel. And there are 4, some would arguably say 5 cases that raise this issue in the Supreme Court this term. And in the interest of time, I really want to talk about one particular case and then another set of cases. Now, keep in mind that the framework for this, the Sixth Amendment guarantees the right of the accused to have the aid of counsel. The Supreme Court has interpreted that to mean that you have the right to the effective assistance of counsel. And to raise a claim that you have received ineffective assistance of counsel to a level that violates the Sixth Amendment, you have to prove that your counsel was deficient, and then you have to prove that that deficiency was prejudicial. That is, that in the absence of that counsel's poor representation, the proceedings might have turned out differently. Now, the Supreme Court's been kind of not very sympathetic about this question. They have afforded a presumption of effective assistance of counsel. In the case of Bell versus Cohn, you may remember in 2002, 8 justices on the court, led by Justice Rehnquist, said that it was likely or reasonably a strategic decision for counsel at the sentencing portion of a capital trial to put on no witnesses and to not make a closing argument. 2 years ago in Wood versus Allen, Justice Sotomayor led the court in suggesting that it was reasonable for the trial court to determine that there was not ineffective assistance of counsel in a case in which an attorney who'd only been admitted to the bar for 5 months was handed the responsibility of the sentencing phase of a capital trial and failed to do any investigation or put on mitigating evidence that might have helped the defendant. So the landscape doesn't look great for these claims, but the fact that the Supreme Court's taken so many and that they raise this issue from different perspectives, I think, seems particularly important. One set of cases, that's 2 of them, Lafler versus Cooper and Missouri versus Frye, raise the issue in the context of pleas. What happens when counsel does one of 2 things? Either fails to convey to the defendant that the prosecutor made a plea offer, or so provides incorrect advice to the defendant, as in Lafler versus Cooper, where the defendant was prepared to admit that he had shot a woman 4 times, and was prepared to confess and to try and get a plea, but his attorney told him that the prosecutor could not possibly prevail on a charge of assault with intent to commit murder because all of the shots, the 4 shots that he had fired and that had landed into the victim, were all below the waist. And counsel advised his client that therefore the prosecutor could not prevail on this charge. It turns out this is absolutely not true. And so they went to trial, and the defendant, of course, was convicted. So we've got the plea case, and a significant issue in the plea cases is what's the remedy? If you wanted to say, for example, in Missouri versus Frye, that it's ineffective assistance of counsel if the counsel gets the letter from the prosecutor saying, here's the plea offer, and never tells the client, is it possible to imagine what the remedy would be? So in the trial court, the district court said, well, we ought to require specific performance of the plea that was offered. In other words, we ought to require now that the defendant now be allowed to take the plea that was originally offered that he never heard about, right? And there's some contention about that, and Neil may have something to say about whether or not that is a workable solution to the problem.